Number 38, Skanska versus Atlantic Yards. Counsel?
Good afternoon. If it please the court, I'd like to reserve 2 minutes for reply.
Of course.
Your Honors, Skanska had the contractual right to receive, and B2 had the contractual obligation to provide lien law 5 security as a matter of contract.
Where?
Where, yeah.
In addition to 17.3 of the CM agreement, which provides that performance is, the performance validity and interpretation is in accordance with the law of the state of New York, in addition to the general principle of law that the law is written into every contract. We also have general...
Does that mean that whenever the law of the state of New York has some provision about something, and in this case, we have lien law section 5, which, as I read it, obligates the state ESD here to procure that kind of, some kind of security, that we can then read an obligation into a contract that the parties didn't place there?
You can, and certainly in a construction setting. Construction is one of the most highly legislated industries we have. In addition to the general principle of law, we have General Business Law 757, which provides that in a contract, if you provide, in New York, if you provide that a foreign law governs the parties' rights, it's void as a matter of law. Now, the argument that is being advanced by B2 is that because it was not specifically mentioned, lien law 5 was not specifically mentioned, Skanska has no contractual lien law rights. That would be a direct affront to lien law 34.
Well, let's assume that that's not accurate, that Skanska does have some rights under the lien law. Aren't those rights as against ESD, Empire State Development, who perhaps, at least in your view, didn't do what it was supposed to do?
No. For the first and foremost is if there's a contract right that exists, okay? It is a cumulative contract right under the court's decisions in, bear with me, I'm sorry. The Assured Guarantee via J.P. Morgan in 18 New York 344, ABN AMRO Bank, MBIA v. MBIA Inc. in 17 New York 3208. Those are both dealing with the rights against the ESDC, if you would. As far as a tort right against ESDC,
Well, a statutory right or some kind of right, yeah.
well, firstly, in this case,
We have Article 78, for example,
Right.
to compel the state to do what it is supposed to do or to get redress for its failure to do that, right?
and again, under the precedent of this court that I just cited, if you also have a contractual right, they're cumulative, and you can exercise your contractual right.
Okay, so
Which is
that
what
gets
we're
us
doing.
back to whether or not there is a contractual right here.
Yes, and I was at Section 34 of the lien law, which prohibits in a contract a waiver of a right to lien. Now, it is the argument of the respondents that because it was not specifically placed, then Skanska waived its lien rights. And that's abhorrent to the law. Westfair versus Aetna Casualty and Surety, again, of this court, provided that the surrender of protective rights as a prerequisite to obtaining a contract or a subcontract is repugnant as against public policy. So and there's no question as well that the lien law 5 bond is a lien law right and is a lien for the purposes of the lien law. It was placed there by the legislature into the lien law. It wasn't placed in the public authorities law. It wasn't placed in the general business law. It was placed in the lien law because the very purpose of the sponsors was to secure the lien rights.
So what constitutes an undertaking?
An
Other than-
undertaking?
The bond is separate, right?
Bond-
Bond is separately mentioned.
Right.
It's not a letter of credit,
Right?
given the legislative history, right?
If
Or
we're,
it could be.
I think if we're talking the form, okay, it could be a pot of gold. All right? I think what is important is the substance. Is this document, or is this guaranteeing to the beneficiaries, not to the ESDC? No. That's the obligee under this completion guarantee. But the statute requires to the beneficiaries of the law a direct guarantee. And if there's no direct guarantee,
But what would
that's
that
what
be is what
controls.
I'm saying. I understand your position, which is merely promising to pay doesn't satisfy the lien law. So other than a bond, a letter of credit, what else could it be? Putting aside the pot of gold, I assume you mean like actual finances of sorts in some account or an escrow, something like that?
Yes. The legislature wanted to make certain, because you can't file a lien, that the contractors and subcontractors are paid. So when you look at the undertaking, and again, with a capital U, it'll be 2501 of the CPLR. With a small u, it still must be a fund, something that is regulated. For example, a bond is regulated by the insurance law. So if someone goes bankrupt, you have the fund. Letters of credit, you have banking and banking regulations. Some legislative or some statutory, some control, so that the guarantor simply going bankrupt doesn't leave everyone high and dry. And so that is what I would say to Your Honor is the undertaking. Something that goes to the beneficiaries, and how far you can go, it's got to be something subject to the laws, something subject to certainty that the money's there at the end of the day for the beneficiary.
I'm struggling with one particular part of your argument, and you can correct me if you think I'm wrong. Is it correct that the guarantee was by FEC, who's an affiliate of FCRC, to Empire State Development Corporation, ECDC?
Yes.
ESDC, is that correct?
It was
That
by an
sequence.
affiliate?
FCE to FCRC, as an affiliate of FCRC, and it was to the Empire State Development Corporation.
It was by Forest City Enterprises,
Roughly, he's
which
shaking
is
his
an
head, yeah.
affiliate of Forest City.
Right, Forest City Enterprises, which is an affiliate of FCRC, right? And then it was to Empire State Development Corporation. Now, these are all non-parties.
The Enterprises is a non-party. Forest City, we did assert that they are a party. We asserted that on a piercing, and the appellate division did reverse that.
All right, so FCRC isn't a party, but the affiliate is a party. Is that correct?
Forest City is a party. Forest City Enterprises is not a party.
So Forest City Radnor Enterprises posted a guarantee, correct?
I think it's just Forest City Enterprises, Your Honor.
Yes.
They were the
So
ones
how
who
does
signed.
that fold into our analysis?
They're a third party, and they may
Right.
have a bunch of money, and they've already undergone certain transitions. So, again, we make the argument about finding where and that goes into the dissent, finding where the money is. I mean, but they can go bankrupt tomorrow as well as rich as they may be today.
Have you alleged any damages? Have the contractors suffered any damages as a result of what you say is this breach of contract or this inadequacy of?
Very well could.
Well-
Millions of dollars are owed. The first thing is there a contractual promise? And we respectfully remind the court, when
But don't
we
you have
found
to
that-
allege that some damages have been incurred on a breach of contract cause of action?
you have to allege a breach, and the damages are chasing the money, or being deprived of your legal right.
But how do you know that you're going to have to chase the money? I mean, maybe
Me too.
FCA's got that pot of gold.
B2? B2 is a single asset entity, which,
No, but it's, but the obligation's been guaranteed by FCE, that's,
the guarantee has not been, there's no guarantee to the contractors here, and that is the principle. The obligee is the ESDC, not the contractors. That is the failure. That is the primary failure. It's conditional, it's limited, and it doesn't go to the very beneficiaries that the law says it must go to. And that was, and I'll be back in 10.
Thank you. You will. Thank you, counsel. Counsel?
Thank you. May it please the Court. First, I'd like to address the contract issue, and I think that's really the critical issue here. There is no provision in the contract requiring a bond. The dissent in the appellate division said there's a provision saying you have to comply with New York law, but there isn't. The provision is simply a choice of law provision. So what they're arguing for here is if you have a choice of law provision, it turns every statutory obligation into a contractual obligation. That cannot be right. There is, in fact, a provision in this contract in which they are entitled to demand financial assurances. That's what they bargained for. There's also a provision in this contract which says that they have to comply with statutory requirements regarding safety and scaffolding laws. So they knew how to put statutory obligations and turn them into contractual obligations when they wanted to. The irony here is that I think the...
So what protections do they have?
Well, they have...
Excuse me.
I'm
If-
sorry, Your Honor.
If the company goes belly under or disappears,
Well,
what
they have-
protections do they have to get paid for the labor?
They have a guarantee of a company that had $10 billion worth of assets, a public company, and ESD made the determination that that was adequate. And it illustrates the problem here when you try and...
All right, so what recourse, from your side, do they have?
Well, it's possible that they can sue as a third-party beneficiary.
Wouldn't you still have an obligation under the statute? Let's say you're right, you don't have an obligation under the contract. You still have an obligation under the statute, don't you?
Yeah, and we believe we fulfill that. We did this project
Well,
through...
was ever, there's a bond, Section 137 bonds, state finance law bonds. Was that ever posted?
No, it's not relevant, because that's for...
Well, let me answer my question.
The answer is no, because this is not a public...
So it wasn't ever posted?
No,
right.
that's for a public improvement. That's for where you have a contract with the state or municipality. This is a hybrid project that's governed by Lien Law Section 5. So Section 137 is state finance
And
law.
what's the purpose? What's the purpose of Section 5 with respect to these hybrid projects?
The purpose was to provide some protection for contractors and subcontractors. That's clear, that prior to the enactment of Lien Law Section 5, they had no protection at all.
What's the nature of that protection? Is that protection a mere promise? That
No.
You don't need the statute for that. What are you getting with the statute?
Well, you do need the statute for it, because without the statute, you'd have the only obligation would be on the part of the owner of the property, the B2 owner, which, as Mr. Miller pointed out, is a single asset.
But why would the legislature go through all that effort to merely say, you can just promise you'll pay?
Well, but it's not just a promise to pay, it's a guarantee, which actually this court has defined an undertaking in the Ohlendorf case as a guarantee. And
So
you have-
having a promise, so what's the difference? What's the difference?
Well,
What
because
more do you get than a promise?
you get $10 billion worth of assets behind that promise.
And
So if you
how
have-
can the unpaid laborers, assuming that there are some, how could they, let's say, levy on the guarantee?
Well, you can't, you don't levy on
Right,
it.
so how are they going to be able to make good on it? How are they, if they're unpaid, what good does the guarantee do them?
The guarantee, well, again, this issue has not been reached, but it's quite possible that they are a third-party beneficiary of that guarantee.
Well, and
they
is
can
it
then-
quite possible that they're not?
Well, again, we haven't briefed or argued that issue, and that's part of the problem here, is that this is a determination that was made by ESD. And ESD is not here, they're not a party to this proceeding. If they were going to challenge that, they should challenge it in Article 78, where a record can be developed by ESD as to why they made the determination that they did, because they did make a determination that this was adequate, and that is within their discretion. If they've abused their discretion, then that's something that gets challenged in an Article 78 where they can make a record, but not when someone's just trying to terminate a contract, which is all that's going on here. They're just trying to walk away from a contract and use this.
So you read the statute and the legislative intent to have these suits against the state? Is that
No,
what you're saying?
the statute original was drafted to only require a bond, as I think your honors
Yes,
know.
yes.
It was changed at the request of the various agencies, including the MTA, to provide them with discretion to evaluate each project on its merits, make a determination.
Provide flexibility, but again, isn't whatever they have to agree to have to be in furtherance of the purpose? And if the purpose is to make sure people get paid, how does merely a promise to pay
Well, again,
ensure that purpose?
Well, again, Your Honor, if I borrow money,
How is a promise like the bond?
it's not the same as a bond.
No, it is not.
It's not the same, and there's
Meant
nothing.
to be, that's why it says undertaking.
Right, it's not the same as a bond, and if it was be the equivalent of a bond, they would have said so. If it had to be.
Well, it could be the equivalent of what a bond is supposed to serve, but just not through a bond, which I think is their point.
Right, but again, that language was inserted because the agencies wanted to be able to evaluate the needs of each particular project and make a determination.
That a bond might not be appropriate, but not to escape the purpose.
But I
of the law, right?
I don't think the purpose is being escaped. When you borrow money from a bank and someone guarantees that it's going to be repaid, the bank
And
looks
then,
at,
and then the bank goes under.
well, the bank, you mean the guarantor goes
Well, the
under.
guarantor, I'm sorry. Yes,
Well,
yes.
but that's an
Goes
evaluation.
under, then what?
Well, that's an evaluation that ESD made. ESD made the judgment that a guarantor, a public company that has 10
So you're
billion.
saying their recourse is only if they're a third-party beneficiary against the state? And you think that's the intent of the legislature? with
Well,
this
the other thing I would say is if they felt that that was inadequate, there is a remedy for them. The remedy is not to sit 2 years and do the work and then walk off the job and use this as an excuse, because there is no contractual, there is no
The
contract.
remedy, in your opinion, is?
They could have brought an Article 78
So
proceeding.
again, it's back to the state.
Yeah, well, if they feel that the security was inadequate, they had a remedy. They also could have bargained to put a bond, any requirement they wanted into the contract. And if they weren't satisfied with that, they didn't have to do the job. That was a
I guess
decision.
one of the, does your rights under the lien law, by you, I mean a party who's got a claim under the lien law, exist outside of the contract? What would you say to that question?
They're right, well, again, this is
Well,
a,
kind of straightforward. Does the lien law remedy, you're a contractor, you claim somebody owes you money, they haven't paid you. In this hybrid situation, do you have a right under the lien law to bring an action?
you do not have the right to file a lien for this kind of a project, so you don't have the right to foreclose any lien.
And if there's nothing to foreclose on, right?
There's nothing to foreclose on, that's correct. You cannot, just as in a public.
So unless there is a bond or other undertaking that has been provided per Section 5 of the lien law, right? And it wasn't provided here.
Well, I beg to disagree with that. It was provided. I mean, the question of whether it met, I mean, these requirements that Mr. Mell is referring to are not in the statute, that it has to be with a surety or it has to have a specific fund. It's not in the statute. Those may be the requirements for an undertaking under the CPLR, but they're not the requirements that are in this
So are you
statute.
saying that-
One other question. I'm sorry, Judge, just this last thing. So let's assume, your argument, though, is that it's not provided for in the contract. If you're going to do something, you can't do it under a breach of this contract.
Correct.
That's the core of your argument. Your core of your argument is not that the lien law would never apply, or lien laws, you don't care. Your argument is,
I'm simply saying you cannot terminate this contract for failure to fulfill
I see.
that statutory obligation. That's what the motion court decided. I think the appellate division got sidetracked. If you look at the majority opinion, even though we're asking for affirmance, you'll see that what they say in the end of this discussion was that they say something like, because Skanska is only asking to require the posting of a bond, we're not going to decide something. But that's not what Skanska is asking for. They're trying to terminate this contract on the ground that the lien law wasn't complied with. And I'm simply saying you cannot terminate a contract.
You're saying you can't terminate a contract in the context of a breach of, you can't enforce a lien in a breach of contract action unless it's expressly laid out.
Yeah, I'm saying
It's in the contract.
Yeah, I'm saying statutory obligations do not become contractual obligations merely because you have a choice of law provision in the agreement. The consequences of that are, if you just think it through, if you violate discrimination laws or you don't pay your taxes, can someone terminate a contract with you? It has to be that's what this case is about. It's a contract case. It's not an attempt to enforce a lien. It's not an attempt to require a bond. It's not an attempt to have a third-party beneficiary claim.
I know you're calling it a choice of law provision. Okay. Let's say we disagreed with you. Or let me put it another way. What language, other than saying we're subject to lien law section 5, other than that, short of that, what else could they have negotiated in this contract?
Section 3.5 of the agreement.
Okay.
And you'll see in Section 3.5 that they negotiated an entire provision that we had to comply with safety rules, with the scaffolding law, with the statutory requirements. And if we had not, that would be a breach of
So
contract.
if it had said, and otherwise, all laws of New York State apply to this contract, would that have worked?
Be closer. Be closer. I mean, we haven't,
So if we disagreed with you that this was a choice of conflicts provision, and we read it to be an agreement of these parties that you would be subject to all of the laws of New York State, would that include the lien law section 5?
it would, but I don't think you can read it that way. I think it's very, very clear. It's a standard choice of law provision that's in every contract, and I think you'd be hard-pressed to read it as a contractual obligation to comply. And again, they knew how to bargain for a provision like this when they wanted it. They put it in Section 3.5. And the fact that it's not there is an indication that it just wasn't part of the deal. And I think it's 4.3 is the provision that says what they can do if they have qualms about payment, which was to demand financial assurances. And frankly, that was another of the grounds that they used for termination, to justify termination of the agreement. So they negotiated for what they wanted. And if they didn't want to proceed in the absence of that provision, no one put a gun to their head and forced them to go ahead and do this job. And it's not like they didn't know that there was no provision in there. So I think, going down the road of saying every statutory obligation is a contractual obligation is a pretty strong, pretty dangerous thing to do. And again, I think that, so I think the dissent, I was going to say, also got misdirected because the dissent said, because Skanska said in their brief, that the contract contained a provision requiring compliance with New York law, and then they cited Section 17.3. And my time is up, but I think when you look at 17.3, you'll see it does not say
Thank you.
that.
Thank you, sir. Mr. Miller, your colleague makes the argument that had you been concerned about the adequacy of the security, you would have brought in Article 78 against ESDC. So how do you respond to that?
Skanska did not even know that this was the quote-unquote substitute for the bond until we were in the appellate division. That was when it was first argued. Skanska was asking for the bond. As soon as Skanska learned that they had lost their financing, Skanska said, give me a copy of the bond. And for 2 months, they were put off, and then they found out that there was no bond. At the same time, there was a FOIL request being filed by our office trying to hunt that down as well. So to address it, we didn't even know about it, number one. Number two, as far as what's required, we respectfully bring the court's attention to Legnetto, which we cite, as well as Chittenden. Legnetto in this court said, under 137, the contract is required to post the bond, even though it's the same language. It placed a requirement on the contractor, because that's consistent with the sponsoring statements. The sponsoring statements is to require the owner to post the bond.
Just to clarify, is he correct Do you agree with him that what you're seeking to do is terminate the contract?
This is not just about it. This is a breach. We noticed, under the contract, we gave them notice of a breach. They had 45 days to cure. 45 days to cure, and they thumbed their nose at Skanska, okay? They could have gotten that bond and addressed their contractual obligations. They didn't say boo. They just...
But this arose because they imposed a deadline for completion of the work, and at that point, you said you were terminating the contract. Do I have that wrong?
There was yeah, I believe it's not precise. There's a 146-page letter sent of all the miscellaneous breaches. That's in the record. And the performance was continuing for 45 days thereafter because that's what the contract provides, all right? And then at the end of 45, when they cured none of it, there was a termination. I would also like to jump, if I can. 17.3 is not a choice of law. It's a governing law provision. 14, the scaffold, he referenced the safety. It just said in 4.5, that simply says that a safety plan will be established in Exhibit L, and there is nothing in Exhibit L. So that wasn't a bargain for law. That was just there'll be a safety plan. There was nothing about the scaffolding law. I mean, could we have bargained to say, you know, something, sidewalk bridges aren't required?
Well, if you could bargain away provisions of law, I don't think the scaffolding law would survive any contractual relationship between any businesses in New York State.
Right.
We all know that you'd
Yes.
be bargaining away. That's pretty straightforward. Listen, if the lien law, I guess the question in my mind, does the lien law have to be expressly included in a contract to apply in other situations? And the answer to that is no, it doesn't.
No.
Of course it doesn't. So why would it have to be included here? Well, let's assume that it doesn't, but that doesn't mean that you would have been able to file a lien under Section 5.
Right, because there's no fund.
So the argument that that the lien law applies to you would be incorrect by the appellate division, wouldn't it? Because you wouldn't be able to use it.
Well, no, the lien law is, also includes in Section 5 the bond. And the legislature equated to a lien because they placed it in 5 I'm repeating myself, as compared with the public authorities law, the general, all the different laws that have regulations on the construction industry. Okay? But they placed it in the lien law because the very purpose of 5 was to give the contractors lien security to the extent that would be possible. Okay?
Thank you, counsel.
Thank you.